Until 2 p.m., maybe just over an hour.
Yes, I think what's going to happen next is we're going to probably pretty quickly end, and then we'll go into our witnesses. So we would ask to have until 2:15 if that's fair. And then I think we should probably well, we're not going to wrap today. I would say that.
Ready, Philip?
Time is 12:51 p.m. and we are now back on the record for open session. And what we are going to do now is we're going to go to the lunch break, and counselors, I think, have agreed on a little bit longer break today. So we will go to a recess for lunch until 2:15 p.m. So we are now off the record. It is 12:51.
Live
Time is 2:16 PM and we are back on the record. And we are resuming with the open meeting portion of Miss Marnie Jones's testimony. And I believe we were at intervener recross of Miss Jones for the for the open part. Is that correct?
Madam Chair,
I believe that we still have commissioner questions on the public portion of
That's
her
correct.
testimony.
Okay. Thank you for the reminder. everyone.
hold on, sorry. My understanding is that we had not finalized our
Public,
cross,
right.
that we were in public, we went to confidential, we came back to wrap up anything in the public, and it then goes to,
So I was right. Thank you, Ms. Trinnell. Your memory does recollect with mine, or coincide with mine on that. So we will go back into cross-examination of Ms. Jones for the public portions of the discussion. And Ms. Trinnell, you may begin.
thank you, Madam
Or
Chair.
resume, I should say.
Thank you, Madam Chair. Good afternoon, Ms. Jones.
Good afternoon.
Just a couple of questions. As the Chief Operations Officer, do you have any idea about what the merger costs have been for Black Hills to date?
Unfortunately, I am not aware what they are to date.
Do you know where I might find that information?
Witness Nooney would have been the one who would have that information.
Okay. Do you know if it's available in the public SEC filings that Black Hills has made that we talked about this morning?
The transaction costs would be included on a quarterly basis as part of the 10Q.
Okay. So we can go back in time and add those up over the quarters.
Those numbers should be in the Qs.
Okay, thank you. And then a final question. We had talked earlier this morning about the significant large loads, 2 to 3 gigawatts that Black Hills is serving in Wyoming. Would you agree with me that those hyperscalers have a choice about where they go?
I'm not sure where the load number came from. That load number is not accurate. And certainly any customer has a choice of where they ultimately want to be served.
Well, not captive ratepayers. We don't have choice, do we?
Objection argumentative.
It's a question. I don't think it's argumentative.
Yeah, overruled. I don't think so either.
So I want to maybe go back to the question. You mentioned the amount of large load that was being served. I guess I'll start there with, I didn't find that to be an accurate statement to start with.
Were we talking about, I don't want to quibble over the numbers. Is it several gigawatts of load? 1, 2, 5? What is it?
We don't disclose our current load that we serve today.
Okay. It's a pipe.
We've identified a pipeline.
Is it? Okay. Thank you for that clarification.
Yes.
The pipeline of load that is in Black Hills system.
Yes.
Those entities, data centers, hyperscalers, whatever they are, they could be in Wyoming, Texas, Montana. Would you agree that they have a choice about where they go?
Any large load customer has a choice of where they go.
Okay. As a condition of the merger, would Black Hills be willing to agree to let the captive ratepayers of Montana have that same choice to exit the system that these hyperscalers have in deciding where they land?
When we talk about choice I'm referring to is they can land in Texas, they can land in Colorado, they can land in any state they want to. Within the premises of our franchise service territory in Wyoming, customers do not have a choice. We have the obligation and the right to serve our customers in that Wyoming franchised area.
So my question, Ms. Jones, is that if the utility that is our monopoly provider decides it wants to serve these hyperscalers, would you be willing, as a condition of this merger, to allow Montana captive ratepayers the right to exit?
No.
Thank you. I don't have any further cross. Thank you, Madam Chair.
Okay, and commission questions regarding the non-confidential matter. Commissioner Pinochi.
Thank you, Madam Chairman. Let's take a look at rebuttal testimony of Ms. Jones. Let's go to page MMJ3, line 15. Give you a minute to get there.
Is that page number 3?
Yeah,
Okay.
MMJ3, that's page number 3.
Okay.
On line 15, it says penalties. And I'm wondering if that means if we're not able to meet demand, there could be a penalty or a penalty if something's not repaired in a timely fashion. Tell me a little bit about that.
So I want to make sure I'm referring. So line 15 of page
New
MMJ-3.
Oh, I'm sorry, one at a time. Line 15 says new performance penalties. Am I in the right place?
I think we're talking about the same line.
Okay. Tell me about what penalties can be done here and what let's talk a little bit about that.
I think if you read the full sentence, it says I address several proposed merger conditions that would impose rigid capital investment requirements, new performance penalties, or operational constraints that are unnecessary given the existing regulatory oversight governing the utilities in Montana. So I think the way I interpret that and the way it was meant to read is that there are lots of conditions that run through this commission for their authority. Did not believe that we needed to have any additional penalties or proposals imposed, given the commission's already right to regulate the utility in Montana.
I'm concerned, and a lot of my constituents are trying to get me to extend that concern out, that with this record growth that's in front of us, that we may not be able to meet that demand. Will a penalty apply if we're not able to meet demand, or we meet demand in another state, not Montana? That's my question.
I guess I don't feel like there's a need for any penalties to be imposed. It is our right and our obligation to ensure that we have safe and reliable service for all customers, whether that sits in South Dakota or that sits in Montana. All customers, we have a right and an obligation to ensure that how we serve them and ensure that our service metrics are meeting the expectations of the commission.
Today, there was public comment from Cascade County in my district that new businesses are coming in and they're concerned demand won't be met. And I want to make it clear to everybody, we are not talking about data centers here. And I'm just wondering if they may have made you aware that my district, the county commissioners have met with Northwestern, and they can't get an agreement to meet the demand of the new businesses that want to come in that does not apply to data centers, right? And I was just wondering if you knew about this.
We are under, right word's not going to, we can't talk to each other about today's business. So we have not shared anything that would not be considered part of the merger in and of itself. We've not shared. I'm not familiar with what's going on in Montana. I would specifically have to refer that to Mr. Merkel or Mr. Lefebvre.
Okay, we'll hold that thought. Let's go to page. Let's go to page 10, line 15. Starting on 14, planning, collaboration, identifying the capital needs, focusing on safety, reliability, integrity, compliance, and growth.
Yes.
Okay. My district is concerned that we can't meet the demands that's in front of us, and businesses that are wanting to build in my district are saying, maybe we've got to go somewhere else. They're telling me that's happening right now. Public comment addressed that today. Now, what I'm hearing is this merger will make us stronger to ensure that we meet that growth. But it would be unfair if my district doesn't feel that we're going to be able to meet the growth that they need without talking about data centers, which certainly will be a factor in Montana. Do you feel that we're going to be okay?
Yeah, I think it's a great question. Earlier today, I know Jason, Mr. Merkel addressed that as well. And I think this is where the merger in and of itself provides really a stronger foundation in our ability to access capital, make those investments that are necessary to meet the growing needs of certainly Montana as well as other states. As we think about, I know you've asked about capital and how we allocate capital. Jason talked specifically about how they allocate capital. I would say very much similar process in Black Hills as well. And there's sometimes seems to feel like there's almost a cap of the capital, that the capital is finite. And I would say in an industry and for which we're in a growing footprint that we're in, capital is not finite. It doesn't mean that it doesn't have ever an end to it, but capital, we will have the capital to meet the needs. And it's even proven more through this merger that as we have capital needs, we have better access to market to meet the needs, to get those investments and implement those assets to serve our customers. So I believe we are better off with the merger and our ability to meet the growing needs and the growing demand for energy across Montana as well as the remaining footprint.
If I was to go back and tell the county commissioners, including the person who had public comment today, everything's okay, we're going to meet everybody's demands, am I okay to tell them that?
If I were for you and had to say, you know what, you can expect the same service or better that you're receiving today. You can expect that there'll be long-term value to customers and our ability to access markets, our ability to make investments, and our ability to serve our customers with safe and reliable service. That's really what should be important to customers. And I think absolutely that is what we intend to do.
They might say, it was unfair of you, Randy, not to mention that this could be the record amount of load we've ever seen. You think I'm okay to say we're okay, even though we're going to see an amount of growth never before seen in Montana?
I want to make sure I'm following your question. You think there's more load growth in your area than they've ever seen before?
Yes.
I think electricity is a requirement of all communities, right? It's the core of ensuring that the communities can survive. And as a provider, that is our responsibility, is to provide and meet the needs of that growing community. And we need to do that through making investments, making sure that we're getting our prudent returns, and serving our customers with safe, reliable service. That is our commitment.
Our next concern is this, that we're going to see a record amount of rate hikes to cover this load growth, that the ratepayer is going to bear the costs, and they're concerned that they're going to wind up paying for demands that might have to do with big companies or data centers. Am I able to say that they won't see an unfair rate hike based on big companies or data centers coming in that'll be unfair?
I want to, specific to data centers, my understanding is that Northwestern has filed a tariff specific to data centers. If you want to talk about just typical growth that's going to happen and the growth that maybe is happening in your area, is that, if that's what we want to address, I think in concept of having access to capital and being able to invest in the system as needed takes money. And in order for a utility to stay healthy, which should also be important to our customers as well as the commission, is a healthy utility is going to require an ability to earn a return on those investments. That is how we ensure that we have the safety and reliability of the overall system. So while we invest, the intent is that a merger behind that allows our costs to be lower than they would have been if this would have been a standalone investment. Because we have, with a lower cost of capital and the benefits we get from bringing two companies together, two employee teams from an expertise perspective, economies of scale from a supply chain, those are all value that ultimately rolls into customers' rates. However, as we continue to invest, you're going to assume that while it does reduce the future need for rate reviews, those rate reviews will exist because investment still is required to meet the growing needs of the communities and the cities in Montana.
Thank you. No more questions.
Further commission questions? Commissioner Bukacek?
Thank you, Madam Chair. I'm referring here to Form 10Q SEC for the quarterly period ending March 31st, 2026. That is 350 Montana Exhibit 63. And I refer you to page 4 of 4. Quite a bit has been made out of this document, and I have
Yes.
several questions.
Yes.
Okay, so I have a question for you about the formatting of the SEC filings that warrants clarification. There are central categories. There's on page 4 of 4, executive summary and recent developments. And under recent developments, which is central, so it's obviously a different category than executive summary, there are different headlines, maybe you could call them, that are bold. The first one is pending merger with Northwestern. The second is business segment, recent developments. And based on those being in a bold format, it would appear that those are separate, that they are not putting the pending merger with Northwestern and the business segment of recent developments together.
Yes, that is correct.
Okay. And so that's pretty clear. My next questions are a little bit on the periphery of relevance. It's on the same page. Bullet point 2 was discussed in cross-examination of you, and it's on this form. So it says under bullet 2, that was referenced in cross-examination, is that new customer seeking to construct a 1.8 gigawatt data center, and they're referring to Wyoming Electric. And the Wyoming Electric website is not part of the evidentiary record, but I was hoping I could ask you, it looked like their Wyoming Electric's work is limited to construction and maintenance.
I'm going to object, Madam Chair. This is an effort to rehabilitate the witness that is properly done by the parties, not the commissioners.
I'm going to overrule and allow the commission questions. I've given commissioners latitude as long as it's related to the docket and the merger. So you may continue, Commissioner Bukacek.
So is Wyoming Electric's work limited to construction and maintenance?
Wyoming Electric is our regulated electric utility serving the Cheyenne, Wyoming area.
Does it have its own generation and transmission?
Yes, it does. Wyoming Electric is a vertically integrated electric utility.
Rest of my questions are moot. Thank you.
Any other commissioner questions? Commissioner Molnar.
Thank you, Madam Chair. Ms. Jones, thank you for taking the seat for so long. You're a champion. You're a rock. Ms. Jones, as operations manager, do you oversee regional issues such as those handled by Southern Power Pool?
Black Hills Corporation overall is a vertically integrated utility. We are not part of an RTO.
Oh, I did not recognize that. Your name comes up as being a member of the Southern Power Pool when you Google Southern Power Pool.
We are part of the imbalance market. On April 1st of this year, we moved from the SPP Weiss market to the California ISO WEAM imbalance market. Otherwise, we're not part of an RTO, just an imbalance market.
Okay. So when you move to the California imbalance market, will that take you out of Southern Power Pool?
We ended our participation in the Weiss market in April of 2026.
Yes, but then did that take you out of the Southern Power Pool totally? Or do you still have concerns there?
I do not have any concerns, no.
Okay, thank you. Darn it, that was gonna be a fun question. Now look what you've gone and done. Black Hills Energy and Northwestern Energy both have a major investor. I know that Northwestern's #1 investor is BlackRock, and I believe that BlackRock is also the first or second largest investor of Black Hills. Is that accurate?
They are one of our top investors, that's correct.
Yes. Okay, BlackRock downgrades utility stock if it does not have enough green energy. Various states have pulled out because of that, particularly retirement funds. Is that why there's a carve out for the protection of your green energy plan in your filing for your merger?
I apologize, Mr. Commissioner. I am not aware of what we're referencing here.
Okay, you have 11 items that are considered will not be affected by the merger. The last one is the Black Hills Energy Green Energy Plan. That is what I'm referencing. Are you aware of that?
Can we reference it in the materials so I can just make myself familiar with what piece you're referencing?
It's right in here if you have half an hour. Are you saying you are not aware of that? Are you aware of the things that are set aside that will not be affected by the merger?
My apologies, Commissioner. If I can get some reference to what's being referred to here, I would appreciate that.
Maybe we can carry you over a little bit and I can look that up.
Commissioner Mueller, are you referring to the green power program that's in the Missoula County, City of Missoula settlement, or is it something else?
No.
Okay.
No, I'm speaking specifically about the merger document, the original agreement.
I'll have to get a reference.
Okay. Are you aware of the green power plan that's being administered by Black Hills Energy?
I'm aware of a tariff that we have
Okay.
in some of our states, specifically to green energy,
Okay.
and that's on the natural gas side of our business.
Okay. Madam Chair, if we could carry this over until tomorrow, even if it's on video, I'd appreciate it.
Are there any other commission questions? Counselor, did you have something?
Oh, well, I was just going to say, we will likely be asking that Ms. Jones can be permanently excused once she's completed testifying. So as far as timing, we're certainly happy to take a break. I just don't know the extent to which she will be available tomorrow once she's excused from the stand.
Commissioner, if you want to look it up, we'll try to give you some time to do that. Are there any other commission questions in the meanwhile? Commissioner Bukacek?
Thank you, Madam Chair. So back to this SEC document.
Yeah.
There was an implication made somewhere in testimony that the Wyoming Electric is a subsidiary of Black Hills. Is that correct?
Yes, Wyoming Electric is one of the subsidiaries within the Black Hills family.
So if you can help me understand, and then Northwestern will be a subsidiary of Bright Horizons if the merger is approved. Is that correct?
That is correct. Black Hills Corporation is the parent company for all Black Hills energy companies. Per the merger agreement, Black Hills Corporation will have a name change upon close and will be called Bright Horizon Energy. Black Hills Corporation in the name will no longer exist as the name.
There's somewhat of an implication that that subsidiary, Wyoming Electric, that has that 1.8 gigawatt data center project, and the subsidiary of Northwestern and Bright Horizons, it was sort of kind of making a correlation or a connection, saying somehow that those were similar. And I was wondering if you could help me, what happens to the different subsidiaries when?
So each one of our subsidiaries is a legal entity. Each one of those legal entities will stay intact as they are today. What changes is that the name Black Hills Corporation will become Bright Horizon Energy. And I'm not going to have the legal name exactly right, but that'll become the new entity that we've identified in the merger or in the merger agreement.
So Northwestern will be one subsidiary and all these others.
Northwestern will be a subsidiary of Bright Horizon Energy.
And then Wyoming Electric will also be.
Correct.
Okay, thank
Yes.
you.
Yep.
Counselors, would you be willing to, or any counselors, would you be willing to help us point Commissioner Molnar to the document that he may have been referring to?
If he could describe it again, that would be helpful
Yeah,
and we can try
I'm
to
not
find
a-
it.
So there are 11 items that are said to be basically agreed to that they will not be affected by the merger. The last one of those was the green energy plan.
Is it Crystal's settlement testimony?
This mine or yours? Yours?
It's like a little puzzle.
All right, we'll just take a short recess and provide an opportunity for Commissioner Molnar or council to locate that document and place it before the witness. Thank you. It's 2:44. We'll go off the record for just a few moments. We off the record now. We'll go back on the record.
Thank you.
The time is 2:47 PM. And Ms. Norcott, would you please repeat that?
Yes, Madam Chair, Commissioner Molnar, I believe if you look at Mr. Bird's rebuttal testimony on page BBB 19, there are 6 bullets. And I believe that is what you were referring to. And it
Yes.
references the Green Power Program
The 6th bullet?
is the 6th bullet.
And would those 6 bullets be things that are already agreed to not be affected by the merger?
Go ahead and read what it says.
Okay, if I may, Madam Chair, I can just read for the
You may.
record what it says. So that the question was, you mentioned earlier that interveners and joint applicants are more aligned on issues concerning the merger versus in disagreement. Please explain where you believe the joint applicants and interveners are aligned. Answer: joint applicants appreciate the thoughtful engagement reflected in intervener testimony and believe there is meaningful alignment across several core areas related to the merger issues. These include, and then the bullet list, costs recovery financing, maintaining ring fencing obligations, labor and procurement practices, continued investment in Montana, meeting customer needs, and the Green Power Program.
Thank you. So do you take that to mean that you are in alignment with Northwestern on maintaining the Green Power Program as it currently exists?
I support what Mr. Byrd put in his testimony.
Can you briefly describe what the Green Power Plan is?
This is a Northwestern program, and I would request that someone from Northwestern would probably be much closer to identifying what it is.
Thank you. I'm not aware that we have a Green Power Program in Montana.
Commissioner Molnar, is
Based
that a
on that,
question?
if indeed that's accurate, I'm done with my questions. Thank you.
Okay. Thank you. And again, Commissioner, I believe the Green Power Program was one of the stipulations with the city of Missoula and county of Missoula County that is in their settlement agreement. And we heard testimony from that witness earlier.
That may well be. I did correlate those. Thank you.
Yeah, no, the question's fair. I'm just trying to give some context. Okay, are there any other questions for Ms. Jones? Commissioner Bukacek.
Here, I'm still struggling with understanding the structure of subsidiaries post-merger, if you could help me out there. So subsidiaries of, should I start over? Okay.
Speak slowly and
Still
clearly and
struggling.
loudly, please.
To understand the structure of subsidiaries post-merger. So the subsidiaries that are currently Black Hills and Northwestern separately, those will become subsidiaries of Bright Horizons. They will no longer be subsidiaries of those individual entities because they no longer exist separately.
Just getting to the document specifically. So Black Hills Corporation today has direct subsidiaries, which are part of my direct testimony, which is Exhibit JA-14. Those direct subsidiaries include one specifically that you asked about, which was Cheyenne Light Fuel and Power Company. It also includes direct subsidiaries of Black Hills Power, Black Hills Electric Parent, Black Hills Utility Holding, and Black Hills Non-Regulated Holding, as well as Black Hills Service Company. Those are direct subsidiaries today of Black Hills Corporation. Post-merger, Northwestern Energy Group, Inc. will also be a direct subsidiary of Black Hills Corporation, which upon closing becomes Bright Horizon Energy. So all of those entities that I mentioned, plus Northwestern Energy Group, will become direct subsidiaries. Furthermore, Northwestern Energy Group, which is also part of the attachment to my testimony will have the same structure that they have in place today. There'll be no changes to that structure. The only difference being is that Northwestern Energy Group will be a direct subsidiary of Bright Horizon Energy at the end of it. Otherwise, there's no other changes to any other org structure at all with this merger.
Okay, thank you.
All right, are there any other further commissioner questions for this witness? Commission counsel, do you have any questions? All right, seeing none. Without objection, we will oh, wait, I'm sorry. We're not finished. We're going to recross based on the commission questions.
Thank you, Madam Chair. Ms. Jones, I think you were just referring to your Exhibit 2 of your testimony and the organizational structure of this entity. Is that right? Which is I think it's a 4-page exhibit that has all of the different subsidiaries laid out in it.
Yes, Exhibit 2 is the post-merger.
Okay, and you have 4 pages in your testimony there?
Yes, I do.
Okay, and then do you recognize this exhibit to be an aggregation of the 4 pages of yours, starting with the parent company of Black Hills? So just to be clear, what you're looking at, page 1, you have a breakout and a reference to page 2 of 4 and page 3 of 4 underneath 2 of those subs.
Correct.
Okay. And I just want to be clear for the commission where you have broken out page 1 of 4 is Black Hills non-regulated holdings, correct?
Correct.
Okay. And then this represents here what you have on page 2 of your exhibit, correct?
I can't quite read it all, but I'm going to, subject to check, yes.
Okay.
Yes.
I don't want anybody guessing.
Yes.
I want the commission to have a good understanding of what we're getting into here. So, and then on your first page, you have page 2 of,
Know that page 2 of 4 is exactly what, oh, it's over here. I'm with you. Okay.
so this would represent, and to be clear for our record, page 2 of 4 falls under Black Hills Utility Holdings, correct?
I follow you. Yes, that's correct.
Okay, and does this accurately represent what you have on page 2 of 4 of your post-merger
The
structure?
middle of your document is the same as page 2 of 4 of the exhibit. Yes.
Thank you. And then page 4 of 4 is the Northwestern group, at which you have,
Page 3 of 4 is the Northwestern group in mine, but yes.
right, I apologize. So does this accurately depict your post-merger representation of what this merged entity will look like?
Agree.
Okay. I'd like to move for the admission of, I guess I'll call it 350 Montana Exhibit 65, but it's Ms. Jones Exhibit 2 as fully represented in one document.
We would object to the admission of that as an evidentiary exhibit. I think that this is a demonstrative exhibit and falls within the scope of a demonstrative exhibit, similar to the map that we saw earlier today. So we would object on evidentiary grounds, but I mean, I would leave it at that.
She just testified that this is an accurate depiction of her 4-page chart of the post-merger
And
legal organization, which I think is helpful to the commission in trying to figure out what it is we're getting into here.
if I might respond, Madam Chair.
Yes.
I think if we've, I think it's also cumulative in that case if we've affirmed that the chart is the same as the exhibit that is attached to Ms. Jones' testimony and shows the same things. We have already put that in the record. It is evidentiary. It is in the evidentiary record. This is a demonstrative exhibit, clearly.
Ms. Trinnell, how do you anticipate that being entered into evidence? Would we take a scan of it and put it in the
We
digital
can,
records?
certainly, we can do that.
Okay. And Ms. Jones, are you absolutely certain that is accurate, an accurate depiction of your exhibits?
No, I am not. As I mentioned, I cannot read each of the words. I would want, before to say it was exactly the same, I would need to check each of the words and lines, et cetera, to make sure.
Okay. Well, I would allow it as long as it's accurate. So subject to check, we'll admit it as
Okay.
evidence and you can check and with your counsel, let us know if there's any errors in it.
Thank you, Madam Chair.
Okay. And we're going to call that Montana 350-65?
Correct.
Okay. Thank you. Montana 350-65 is admitted subject to check for accuracy.
Thank you. May I continue? Commissioner Bukacek had asked you about Wyoming Electric, and I just wanted to ask you, Ms. Jones, is this the entity here that we're talking about, this Cheyenne Light Fuel and Power Company? Is that the entity that does business as Wyoming Electric?
It does business as Black Hills Energy, but we often refer to it as Wyoming Electric.
Okay, so when the commissioners are trying to figure out what you're talking about when you're referencing Wyoming Electric, are we talking about this box right here?
That is correct.
And for the record, when I say right here, I am pointing to Cheyenne Light Fuel and Power Company. I just want to have a good record. Thank you. And so it is this entity, Cheyenne Light Fuel, that has contracted, that has a generation reservation agreement with the 1.8 gigawatt customer. Yes.
Cheyenne Light has a generation reservation agreement with a potential customer.
Of 1.8 gigawatts. Is that the correct amount?
That is the same customer, potential customer, yes.
Okay. And that also has the 200 million customer, what's the right word? The customer credit?
Refundable contribution innovative construction.
Thank you. And that terminates at the end of June, correct?
That is correct.
And so
But if you read the remaining part of the queue gives additional detail as to what happens on that point in time.
this is fully regulated,
Yes, it is.
and post-merger, it will be at the same level as Northwestern, correct?
They will both be direct subsidiaries of then Bright Horizon Energy.
So if something goes south with the 200 million contract, who will be on the hook to pay for it?
There are, within that agreement, there are considerations for that point in time. That would be under confidential treatment, though.
Okay. If there is risk and there are consequences and some kind of a payback requirement post-merger, could that be put on Northwestern Energy Group as a
Objection.
sister company?
Objection. This is outside the scope of the commissioner questions that we had. We're also wading into confidential customer specific information that hasn't been subject to confidentiality agreements with that customer, and falls in line with what we've already previously had an objection sustained to, which is the components of individual customer agreements.
This is a direct follow-up to Commissioner Bukacek's questions about this entity, Wyoming Electric, what it contracted for, and the issue of the risk of what happens if a current contract goes south and there are consequences to Montana's company the commission should know about.
I hear your point. I don't recall Commissioner Bukacek asking that specific of a question. I believe her question was to try to understand the organizational chart and how the subsidiaries interrelated with the parent companies.
I understand that, and I think understanding this relationship and the attendant risks and benefits are fairly within what the commission should be considering.
You're right about that, but the objection is sustained on the grounds that it goes outside of the commissioner questioning.
Okay. I don't have any further questions. I did want to just clarify this, and we can maybe verify it offline, make sure it's accurate. Thank you.
Thank you, Ms. Trunell. So my notes indicate that that was original cross for the open session is completed now. And we've done commission questions on the open session. That was recross on open session, wasn't it? All right, so now we're back to redirect. Would the attorneys for joint applicants like to redirect this witness?
Yes, please.
Ms. Shields.
Ms. Jones, you had a series of questions regarding the corporate structure of Black Hills, soon to be Bright Horizon Energy. Could you talk to us a little bit about how the organizational structure, as well as the future post-merger organizational structure, will insulate individual operating companies and their customers from risk?
Yes, each one of our entities are set up as legal entities. Those that are utilities are regulated by the states specific to those utilities. Each have their own individual ring fencing provisions. Each one of them are set through the rates and regulations within those states that they operate. And specific to Montana, as we have brought forward into this merger agreement or these settlement agreements, is that the ring fencing provisions that exist in Montana will exist exactly how they are post-merger, which is a very large protection for the state of Montana and the customers of Montana.
Thank you. I'd like to back up a little bit. There have been a series of questions, certainly before lunch, regarding data centers, also regarding Colstrip. Is the COO of Bright Horizon Energy, future COO, does Black Hills have any intent to use excess capacity from Colstrip to serve data centers in Wyoming?
Objection. We had numerous objections from the utilities on these lines of inquiry and weren't allowed to ask these very questions. So if we're shut down, then the utility shouldn't be able to rehabilitate and build their case through redirect that we don't get any further cross on.
May I respond? I would respond that Ms. Trunell was actually given quite a bit of leeway, far more leeway than the joint applicants were comfortable with. We went into a confidential session on slides that were directly related to this very discussion here, and we're trying to address what has obviously been a very sensitive area, an area of significant confusion across this entire proceeding. And Ms. Jones is quite competent to respond to this question.
To the extent it relates to the merger, the discussion is open, so I will overrule the objection and allow questions related to the merger.
And then I would just ask that I be allowed to do recross for a full and complete record to the extent that there's some kind of an opening of the door here about what the corporate intent is about using this. And Ms. Jones testified in response to my questions this morning that she didn't know the project and she wasn't able to answer the questions. So
So questions were asked on this topic related to 370 PU. Certainly there were some restrictions, but they were asked on cross. And to the extent that happened, the joint applicants are entitled to rehabilitate. The door has not been opened. And to the extent it is, certainly you are correct, Ms. Trunell, that you would be entitled to recross on that, but it has not at this time. And because of the questions that you asked earlier, the joint applicants are entitled to redirect on those.
So the objection's overruled and you may continue, Ms. Shields.
Absolutely not.
Okay, thank you. If you recall, earlier before lunch, Ms. Trunell, she had you read, I believe it was a line from Black Hills, the SEC 10Q about the rationale for the merger. Do you recall that?
Yes, I do.
Could you explain in your own words Black Hills motives and rationale for moving forward with this merger?
Again, I object. I was held on a very tight leash about what I was allowed to ask about, and I stayed within the confines of the chair's direction to ask about the documents. They are set out in the documents. This is not open mic on redirect. And if there is going to be this open-ended, here's what we want to do, then we are entitled to recross on that and get a full and complete evidentiary record in front of this commission.
If I may respond.
You may.
Ms. Trinnell specifically asked Ms. Jones to read a single line from the 10Q that was allowed into the record. There were multiple bullet points. We are asking Ms. Jones in her own words to explain Black Hills' rationale for moving forward with this merger. I don't know how that is unrelated or irrelevant to the merger application that is before this commission.
Again, Madam Chair, I was not allowed to go anywhere outside the confines of that document. The document speaks for itself. It's in the record, and Black Hills is confined to the case that they put on at the outset, that we asked questions about, that we put testimony in about, and that we're here today asking cross on. This is an unacceptable redirect that is trying to expand a record about what Black Hills' intent and motivation was.
So the objection is overruled. Ms. Trinnell, you did question the witness on Exhibit 63, and that's the Form 10Q. There were several questions on that, and I will allow redirect regarding that document that the witness was questioned on.
Ms. Jones, could you please explain in your own words Black Hills' intent and rationale for moving forward with this merger?
Yes, I can. So Black Hills, I've been with Black Hills Energy just a little over 24 years. When I started with the organization, we were smaller utilities serving Western South Dakota. Over the course of my tenure with the organization, we've had the opportunity to scale our utilities from just over 60,000 customers to where we are today to 1.3 million customers. We've done that through a variety of transactions, with each of them really keeping our employees and our customers at the core of what we do from a scale perspective. So when I look at this opportunity with Northwestern, it's a very exciting opportunity to continue to bring two organizations who are very well run together and find the benefits for employees. And we think about employees, we also think about our communities. Black Hills Energy today serves just over 824 communities. We are the thread of many communities. We are the lifeblood of many communities. And we've been able to continue to do that as we've grown across our 8-state footprint. And this opportunity with Northwestern only further expands our ability to continue to grow as one company together, Bright Horizon Energy. And certainly from a customer perspective, Black Hills has been in business for over 143 years, Northwestern for over 100 years. We absolutely understand the value of our customers. We absolutely understand what customers mean to each of our communities, and our ability to continue to serve them is not just an obligation, but it's a privilege to serve these customers as we grow our footprint. So when we think about why do we want to do this merger, Northwestern and Black Hills operate in 3 of the same states. We both operate in rural service territories.
Madam Chair, this is narrative and way beyond what the question is. And this is totally blindsiding the only remaining interveners here.
Counselor, I agree. It's going beyond the question, and it has become somewhat of an open mic. So we'll ask the counselor for joint applicants to narrow the scope and the witness to. We understand you have a lot you want to say about it, but if you could keep your answers narrow to what's been discussed previously. This is redirect. It's not open direct. Thank you.
Thank you, Madam Chair.
Sure thing. Ms. Jones, I have 2 questions for you that relate to something that came up during the confidential session. In the interest of transparency, I'd like to ask public questions that
Yes.
relate to those topics and for purposes of the commission's awareness. One of the things that came up was potential transmission interactions and potential service to third parties, munis, or co-ops in Montana. Do you generally recall?
Yes, I
that
do.
line? Okay. What I'd like to clarify, is it your view that this merger will enhance the combined entity's ability to serve wholesale customers like muni and co-ops across Montana?
Yes, both enhanced to our retail customers as well as our wholesale customers.
Okay, and to clarify, Bright Horizon Energy will honor its existing agreements and contracts with munis and co-ops and third parties in Montana, correct?
Yes, it will.
Thank you. You had a couple of questions about the Ready Wyoming transmission project. Do you recall that?
Yes.
Okay. I think there may have been a little bit of confusion in the record, perhaps during an exchange with Madam Chair. And I just want to make sure that we have clarification as to who and what the Ready Wyoming project was built to serve.
Yes, Ready Wyoming was approved under a CPCN in the state of Wyoming to serve retail customers.
Again, I'm going to interject and object. This witness told me when I asked about this that she didn't know anything about it. So she said she wasn't familiar with the Wyoming CPCN, and now she's testifying about it. So either we get to cross and get a full record, or they don't get to redirect and have this ongoing narrative that is the end of the story. Cross-examination serves a real purpose in evidentiary hearings like this. We should not be constrained and have a witness given to us who doesn't know anything and then suddenly gains an amazing memory on redirect. That's prejudicial.
Counselor?
If I may respond, there have been at least 2 projects or conceptual projects that have come up throughout the day. There was something that came up during confidential discussion today, to which Ms. Jones indicated she was not familiar with the deck. She did not create the deck. There was a separate project, Ready Wyoming, that came up through the public course of dialogue. And I think the exact issue that Ms. Trinnell is pointing out is the exact issue that we would like to clarify, which is there were 2 projects. Ready Wyoming is a public project that has been placed into service. That is the project that I would like Ms. Jones to clarify the purpose of.
And just for purposes of a clear record here, Madam Chair, the witness could have clarified that in response to my questions and didn't. And so now we're getting it in through redirect questions from narrative questions from counsel. That's not how this process is supposed to work.
Counselor, I'm going to overrule the objection, and here's why. I think we're getting clarification, and it's needed. And as you've stated, I'm sorry you're frustrated, but as you've stated, it's important to have facts in front of the commission so that we can make an informed decision. And there has been some confusion about the planned projects and also the completed projects. And I believe that the question now is about the completed project, and the witness had testified that she didn't have detailed information about the planned projects, that her planning team had been working on those. But for the completed project, to the extent she does, she can answer the question. So you may proceed, Ms. Shields.
Yes, Ms. Jones, you had some questions about the Ready Wyoming transmission project, you recall. Could you please clarify who and what that project was developed to serve?
That project was developed to serve all retail customers in the Wyoming Cheyenne Light jurisdiction.
Okay, and to clarify, that project is in service today, right?
Yes, that project went in service at the end of 2025.
And that project received a CPCN from the Wyoming Commission, is that right?
Yes, we received a Wyoming CPCN for that project.
Thank you. I have a brief question. You had an exchange with Commissioner Molnar regarding Black Hills' possible participation in an organized market. Do you remember some of that exchange?
Yes.
Okay. Have any of Black Hills Corporation's electric utilities participated in the SPP RTO market?
No, we have not participated in an RTO.
Okay, thank you. And then Commissioner Pinocci asked a couple of questions of you regarding concerns he indicated he's heard, I believe, in and around Cascade, regarding Northwestern's ability to serve. Do you recall that?
Yes.
Okay. And while you indicated you were not familiar with those particular concerns, is that right?
That's correct.
Okay. Are load growth, native load growth, non-data center, but native load growth concerns, business, economic development concerns of communities, some of the nature that he's mentioned to you, is that something you've had experience dealing with in other jurisdictions?
Absolutely. We have a desire to serve everyone who wants to be served, and we work hard to ensure that we have the capacity and energy and transmission to enable the economic development and the growth that communities need to see and want to see.
I have no further questions for this witness.
Okay. And would you like to request this witness be excused?
Yes, I would like to request she be permanently excused.
I would request the opportunity to ask one recross based on expanded redirect.
How was the redirect expanded?
Ms. Jones went on at length about intentions of regarding the merger, and I have a very narrow question to follow up on that expanded questions about the SEC filing.
And before I might respond, I believe that I may have inappropriately stated the SEC 10Q filing. I believe that that question related to the S4 filing that Ms. Trinnell asked Ms. Jones a question about a line in the S4 filing, and apologize for that confusion.
Okay. With that, I will allow Ms. Trinnell to go ahead with your narrow question.
Thank you, Madam Chair. Ms. Jones, does Black Hills presentation to shareholders in the merger conference, in the merger investor presentations in the SEC filing and in August of 2025 represent Black Hills rationale for the merger?
Objection. I asked Ms. Jones to put in her own words Black Hills rationale, not the banker's rationale, not the board's rationale, Ms. Jones' rationale.
Madam Chair, we are not here about individuals' hopes and dreams. We're here about an $11.2 billion transaction that represents a sea change for Montana. And I want this commission's record to be clear about what is actually represented as the rationale for the merger. It is about what the investors want, not about what we as individuals want.
Counselor?
I appreciate Ms. Trinnell's testimony and argument. She will have plenty of opportunity to argue through briefs, through legal briefs. Ms. Trinnell has had significant time, I don't know how many hours, to ask questions of witnesses, and asking Ms. Jones, the future COO of the merged entity, her personal rationale for moving forward with the merger is completely within the scope of this docket and within the cross-examination that she has been asked.
Okay. The objection is sustained to this extent, Ms. Trinnell. The witness did go on at length in her narrative response, and if you would like to recross on that narrative response, that would be fine. But to go to an entirely new question or tact at this point would be out of order.
I understand, Madam Chair, and I really had just one very narrow follow-up question, which is for Ms. Jones, as a representative of the corporate entity here today, do the presentations to shareholders that are in the record represent the corporation's actual rationale.
I think there's an abbreviated version of the intent behind the merger.
Follow up on that. Are you saying, Ms. Jones, that these documents in the record that the corporation made to shareholders are an abbreviation of what the corporation wants?
I think there's several documents that define the purpose behind the merger, including my direct testimony.
And all of the representations to the shareholders are relevant, are they not?
All the documents are relevant.
Thank you.
All right. Thank you. Anything further on redirect then, based on that?
No, other than asking that the witness be permanently excused.
No objection? All right, without objection, thank you, Ms. Jones. You're permanently excused. All right, and next we are going to, are we finished with joint applicants? Yes?
Madam Chair, that completes the joint applicant's direct case.
Okay,
We would reserve the right to call witnesses and rebuttal as needed.
okay, that's fine. And so I believe we are ready to move into Ms. Trinnell's cases. And Ms. Trinnell, on opening morning, you indicated Farmers Union needed about an hour for theirs.
It is, I actually have a motion before we move to our case in chief.
Okay, I was just trying to get a handle on timing on whether we should try to get Farmers Union finished today and then go into your next one, or if you prefer to start with your next one. So
I think it's reasonable, Madam Chair, based on my guesstimate of what's going to happen in conversations I've had. I don't anticipate cross, is what's been indicated. Certainly nobody's obligated to that. I think there's a possibility we could get through all three of our witnesses today.
okay,
And we're prepared to bring them forward and put them on.
okay. So would you like to begin your case in chief?
I will start with the Montana's Farmers Union, but before I do that, I do have a motion that I would like to raise.
All right.
I think I heard the joint applicants rest. Did I hear that correctly?
Yes, with the reservation to recall their witnesses, I believe, on the condition of, what was it? Rebuttal, yeah.
So if the joint applicants have rested in their case in chief, our 350 Montana and the Montana Farmers Union would move to have this merger denied on its face. The application is facially inadequate, and the legal standards that the joint applicants are required to meet, the net benefit, the public interest, and the no harm standards, are on the face of the evidence as it sits right now before the commission. They are not satisfied. There is a plethora of absent evidence that shows that the high legal standard that must be met has failed. Everything has been kicked down the road.
I heard your motion, but now you're explaining the motion, so okay, you can go ahead and explain. It's a little different than what I'm used to with motions, so go ahead.
Fair enough. I'm asking for the entire commission to rule on our motion to deny this merger as presented by the joint applicants. The evidentiary record that they have presented fails on its face to meet the high legal standard required under Montana law to do a transaction of this scope, this nature, and this impact. There has been no evidence about how the public interest will be protected. Everything has been kicked down the road. Future promises, all will be well, nothing to see here. That is absolutely inadequate on its face. Under Montana law, this application cannot go forward. We have no burden to present any evidence. And what has been presented so far fails on its face. And we're asking that the commission deny, reject, and not approve this merger as it stands right now.
Madam Chair, if if possible, it would be helpful if Ms. Trinnell could cite to a commission rule or Montana statute that authorizes an administrative agency at this point in the proceeding to do what she has requested. She's provided no basis under Montana law or this commission's procedures or rules, procedures, or practices that it will allow this motion to even be lodged or heard. There's no legal support for this approach in Montana.
Yeah, I tend to agree unless something can be produced that the commission did not publicly notice this meeting for commission action. It's publicly noticed as a hearing to gather evidence. So to ask the commission to act at this time, I think would be improper. Or at least for the commission to act at this time would be improper. I suppose you can ask, but I think we're going to need some legal basis for that in order for the decision to be considered by the commission.
Thank you, Madam Chair. So noted. We are prepared to move to calling the witness for Montana Farmers Union, if that is what the commission would like to do next.
Are you withdrawing your motion then?
I'm not. I understood that it was denied.
Out of order. Let me confer with legal. Okay, I will just note that Mr. Nell did make the motion. We've noted that. Joint applicants responded with requesting a production of statutory authority for the motion. None has been provided. So, Mr. Nell, you can move on with your case in chief.
Just to clarify, under Rule 50, the adjudicatory tribunal can enter judgment as a matter of law if there's a failure to meet the evidentiary burden. So, but we don't need to belabor this point, and we can move on with our case in chief.
Hold on just a moment, please.
Madam Chair, I'm sorry, I missed, Ms.
Couldn't
Trinnell
hear it.
headed down a path and I couldn't hear what she was saying.
Okay, Mr. Nell, would you please repeat that?
I'm asking for a judgment as a matter of law based on insufficient evidence. Under Rule 50, that is a standard that I think can be granted, and I do want to raise this for the commission's awareness.
Madam Chair, if we could recess briefly so that I can determine whether Rule 50 of the Montana Rules of Civil Procedure has been incorporated into this commission's rules, that would be helpful. If it has, I'm happy to address the merits of Ms. Trinnell's motions. If not, we'll renew our motion to have that deemed out of order.
All right, is 10 minutes sufficient for recess?
It is.
Okay, we'll go ahead and go to recess. The time is 3:32 and we'll come back at 3:42.
Thank you.
We are now off the record.
Madam Chair. Thank you. Thank you. I'd like to clarify the motion that I made orally. And it is true that there is no procedural mechanism under Rule 50 for the directed verdict that I had requested. So I would want to clarify that interveners 350 Montana and Montana Farmers Union do not waive our argument that the evidentiary record is inadequate and incapable of sustaining the joint applicant's request for relief. So our request of the commission at this time orally before we move to our case is that the commission, in considerance of its orders 8043J paragraph 8 and 8043K paragraph 37 denying our previous motions to dismiss, that the commission rule and find the application inadequate as a matter of law. The authority for that is Montana Code annotated 69.3.103 1 and 2C. And in addition to that, there is authority under 69.1.110 and the commission's contested case authority under section 24612 MCA to regulate the course of a hearing, receive argument, and determine whether any party has met its burden of proof. Because the joint applicants have failed to present substantial evidence establishing no harm and public interest on the record, we move that the joint application be denied and request that the motion and grounds be noted on the record and that the commission rule on it before its final order, if not before. And finally, for purposes of preserving our record for judicial appeal, we would like also the commission to consider the facts it has seen that evidence was coming in the night before the hearing started, May 11th. Throughout this hearing, we have been talking about public filings made last week that are significant disclosures to investors that the joint applicants did not update their discovery to us by providing to us, and that the issues of coal strip, the IRP, the large load tariff, and final decisions on ESAs have not been provided or open. And so for those reasons, we are asking that the commission find that the application has failed as a matter of proof. Thank you, Madam Chair.
Okay, thank you for the clarifications, Counselor Trinnell, and we will go ahead and hear oral argument from the joint applicants on the motion.
Thank you, Madam Chair. I got to sit at the big kid table and make the argument for the joint applicant, Shannon Heim, General Counsel for Northwestern. So we crowdsourced a little bit. This was a new one for us, and I appreciate Ms. Trinnell rephrasing the motion a little bit because, of course, Rule 50 does not apply in this circumstance. But as we were looking at it, she is correct in her citation. In the law, 69.3.103 does apply, and the commission does have broad statutory powers, and the evidentiary requirements of MAPA do allow the commission to look at whether or not an applicant has met evidentiary standards. The commission, once in the last 20 years at this point in a hearing, has determined that an applicant has not met their standard and basically gave a directed verdict to the other side one time in 20 years. And so in that case, which was in the matter of DI garbage disposal of Bozeman doing business as Redbox, it was docket 2021.03.043. We can circulate this order if that's helpful. basically Redbox presented no evidence whatsoever. And so the commission found that it was appropriate at that time to basically give a directed verdict to the other side. It was a garbage hauler case, and there was just absolutely no evidence presented in order to support their application. In paragraph 30 of the order, the commission wrote, because they did put out a written order after they granted the directed verdict, they said a directed verdict is appropriate if, quote, only one conclusion is reasonably proper, end quote. Evidence must be weighed as most favorable to the non-moving party. And if it is reasonable that the commission could draw a different conclusion from all the evidence, then a motion for a directed verdict must be denied. So of course, we would argue that on the facts before this commission in this case, there is absolutely an extraordinary amount of evidence before this commission. So to turn to the merits of what is before this commission, not to argue the case, but just to outline in broad strokes what is before the commission. And I think we will agree to disagree for the purposes of this motion, whether or not we need to demonstrate net benefits. The evidence before the commission today absolutely does demonstrate net benefits to customers. The settlements that we have put before the commission have, just for example, a $10 million customer fund that will, if approved, go to customers. We have demonstrated that there is absolutely no harm to customers if the merger is approved. And we have outlined an incredible public interest in granting the merger. There's voluminous evidence in the record. We've given you 5 exceptional witnesses with deep utility experience. They have given you pre-filed testimony, rebuttal testimony. The parties have put voluminous data responses into the record. There are 4 settlements reached between numerous parties. The parties have put their own settlement witnesses in front of you with sworn testimony, pre-filed settlement testimony, and live testimony. The strong direct case in front of you was enhanced by these settlements. There is so much evidence in front of the record that stands in direct contravention to the only directed verdict ever granted by this commission at this point of a case. I strongly urge you to deny this motion right now today and to put this behind us so we can just continue to move on with this case. Thank you.
Thank you. Okay, the chair does remember that case that was just referenced, and I think Commissioner Pinocci was here during that too. That was a small garbage hauler that failed to produce any witnesses when we were in hearing. So thank you for the reminder. So this is more than procedural. And I did look up that case and how the commission handled that before. And in that case, the chairman raised the issue to the full commission. And just for the purpose of deciding the party's motion. And so with that, I will raise 350 Montana and Montana Farmers Union's motion to the full commission for a decision at this time. Is there a commissioner that would like to make a motion on how to decide 350 Montana and MFU's motion for judgment as a matter of law? President Lilburn?
Yeah. Madam Chair, I move to deny 350 Montana and Montana Farmers Union's motion for judgment as a matter of law on the ground that there is sufficient evidence in the record to support the application, Madam Chair.
Is there a second?
I'll second.
Okay, the motion has been made and seconded, and we will allow discussion on the motion itself. Is there any discussion on the motion itself? Commissioner Molnar.
First, Madam Chair, I have a question of our legal staff. If somebody votes yes or no on this motion, does that make them prejudiced if the motion goes forward and they vote after this point?
Commissioner, the motion really hinges on whether there's sufficient evidence in the record to this point or not on whether you are going to approve or deny the merger at this point. So if the commission finds that there's not sufficient evidence to continue with the case and they haven't been able to provide any evidence, then in the past, the commission has one time said they adopted the motion because there was no witness and no evidence presented to the body. So you're not prejudicing yourself simply by voting on the motion. Okay. Further discussion on the motion. Commissioner Pinocci.
Hey, can I ask Northwestern Shannon Heim a question?
It kind of opens things up. Commissioner, you can go ahead and ask the chair and then
I'll ask you guys a question. I'll ask you a question. Okay.
Okay.
So, oh, come on. Oh, fine.
Question?
All right.
Where are we at?
Can I have a copy of your motion? We are on discussion and see no further discussion.
Wait a minute.
I will. Commissioner,
I'd like to,
okay,
yeah, I'd like to opine on this if I might.
you on the motion.
Yes, on the motion. Madam Chair, my fellow commissioners, I didn't get them all written down, but I got down the $10 million fund to ratepayers, the question of no harm, the question of 5 witnesses and the 4 settlements. I'd like to address those. If somebody can give me a more complete list of what was said, but I think this will go pretty much to what I have to say on the motion. It was said that there's a $10 million fund. As I recall, that's $18 per family one time for what might be a high risk endeavor. To say we're going to give you $20 and you owe us $2 change is almost an insult. You're better off not doing that. No harm. Harm was discussed continuously.
Commissioner, I'm going to interrupt you for a moment.
Okay. Am I allowed to discuss why I would vote?
I want to help. I want to try to help you, not prejudice yourself, because the evidentiary record is not complete yet.
Right.
And so it sounds to me like you're going into debate on the overall, whether the merger should be approved or denied. And what we have right now is a motion before us regarding whether there's sufficient evidence that's been provided in this case or not at this point. And so I'd be careful about separating whether you believe sufficient evidence has been presented versus, you know, your overall feelings on the merger and the settlement agreements and those things.
I appreciate that, Madam Chair. I'm walking a tightrope. I don't want to make it any tighter if I don't have to.
Yeah.
However, and I'll throw this to our legal, these were just now mentioned as to opposition to the motion. And I'm not really addressing the entire issue. I'm addressing their comments as to why we should vote against the motion.
Yeah.
So is that okay or is that not okay? If it's not okay, exactly what can we say? Because
Okay.
that's all that's here.
You're gonna be able to say what you want to say, but my caution is that the oral argument went to the fact that evidence has been presented on these numerous things, not on whether the commission should agree with that evidence, but the fact that it's been presented. So if you believe evidence hasn't been presented, sufficient evidence hasn't been presented, then that's what we're making our decision on right now.
Okay, then I'll take another stab at this. If I wind up shooting myself in the foot, reloading and assaulting the other penny loafer, please stop me before I go any farther. But I would say that of the 4 things that I wrote down, there is not sufficient evidence to go to the criterion of no harm, et cetera. The 3 things we're supposed to be looking at, they're not there. And once we adjourn, no more can be brought in. I'm not seeing it. And I've been involved in mergers of my own, and there's unforeseen. So if you're not starting out with a strong evidentiary base, you're probably going to wind up in the deficit. So with that, I am going to not support the motion, Madam.
Okay, thank you, Commissioner. Further discussion on the motion? Commissioner Pinocci.
Yeah, I want everyone to know that I had a good question and council gave me a good answer. And I want you to know I got an answer.
Was it fun? Okay, further discussion on the motion. Commissioner Bukacek?
Just very briefly, there is sufficient evidence to continue with this case. I'll be a yes vote on President Wellborn's motion.
Okay. Commissioner Wellborn, did you have anything before I chime in? I'm trying to stay neutral here and let the commission decide this before I say anything. So, okay, so I remember when this kind of motion was raised before, and it was stunning that it happened in a hearing in this room previously. But that hearing was also stunning in that the applicant failed to produce a single witness. So this is quite different than that. There is lots and lots of witnesses and testimony and evidence that's been presented. I am not going to reach a conclusion on whether the merger should be approved or not. I'm going to wait until the evidence is analyzed and our technical staff has an opportunity and our legal staff have an opportunity to go through and synthesize it, and I have an opportunity to go through and synthesize it. I think it's going to take several weeks to review and digest the evidence that's been presented so far. And if this motion passes, there will be additional evidence also to consider as 350 and Farmers Union present their case in chief and their witnesses, which may shoot holes in the other evidence that's been presented. But I see no prudent way that the commission could actually approve this motion today. So I will be supporting the motion. And with that, I will restate the motion and then call for a vote. The motion before the body is to deny 350 Montana and Montana Farmers Union's motion for judgment as a matter of law on the ground there is sufficient evidence in the record to support the application. All those in favor of the motion will say aye. Aye.
Aye.
And all those opposed will say nay.
Nay.
And the motion carries 4-1 with Commissioner Molnar dissenting. All right, now we are back to Montana Farmers Union case in chief. Is that correct, Mr. Nell?
Thank you, Madam Chair. It is, and I had indicated to the chair that I would flag when I was speaking for exclusively one intervener or the other, and I am now representing and speaking for Montana Farmers Union. So, Montana Farmers Union will call Walter Schweitzer. Thank you.
Mr. Schweitzer, were you in the room when we swore in the witnesses on Tuesday morning? Okay, if you could, sorry, I didn't catch you in time. Can you stand up?
I was not.
Can you stand up, please? I was
Yep.
going to try to catch you before you sat down. Raise your right hand. Do you swear to tell the truth and nothing but the truth?
I do.
Thank you. You may be seated. Mr. Now.
Thank you, Madam Chair. Mr. Schweitzer, did you file pre-filed testimony in this docket?
I did.
And is that before you marked as Montana Farmers Union Exhibit 1?
Yes, it is.
Okay, and did you file pre-filed cross-intervener testimony in this docket?
I did.
And is that before you marked as Montana Farmers Union pre-filed direct cross-intervener Montana Farmers Union Exhibit 17?
Yes, it is.
Okay. If I were to ask you all, have you had a chance to review these two pre-filed direct testimonies?
I have.
If I were to ask you the questions here today under oath that are presented in those testimonies, would your answers be the same except for any changes?
Yes, it would.
Do you have any changes to your testimony?
I do.
Okay, let's just take those one at a time. What are those changes?
On page 3, the footnote number 1 should read MFU 009
Okay.
instead of 002.
Okay. Any other changes?
Yes, there is. On page 10, footnote 16, it should delete MFU exhibit 002.
Okay. Any other changes?
There are not.
Okay. With that, I move for the admission of Montana Farmers Union Exhibit 1 and Exhibit 17.
Are there any objections?
Madam Chair, if that is Mr. Schweitzer's bare testimony without the exhibits identified in that testimony, we have no objection. If that includes the exhibits, I'd like to be heard on the underlying exhibits supporting his testimony.
Mr. Now.
We are including the exhibits and I think some of them have already been admitted into evidence. Montana Farmers Union 5 is the IRP, which I think was admitted into evidence with Mr. Merkel, is my recollection.
I don't believe that it was.
And if it's the joint applicant's intent to object to every exhibit, we can go through them one by one, and I can make if that's what we have to do.
Mr. Now, first of all, what was the testimony that you were moving? It was MFU what number?
MFU Exhibit 1 is the direct testimony, and MFU 17 is the cross-intervener testimony. And we are moving it with the exhibits included.
And Madam Chair, if I might, we would object to the separate introduction of MFU 00. Well, so
Which one is it, Mike, that you're objecting to?
hold on. So did you label
His pre-filed direct testimony is we are marking as MFU 1.
I'm sorry. Thank you. Madam Chair, we would just for purposes of keeping a clear record, we would object to MFU 2. You've previously ruled on the data requests and the responses to the data requests. You've admitted what you believe are appropriate and excluded what you believe are inappropriate. So we would ask to have MFU 2 denied. To the extent that MFU 003 is already in the record, we would ask that it not be readmitted. And those are MFU 3 and 4, I believe, are responses to data requests. So those don't need to be readmitted. We also object, we have no objection to the introduction of the IRP if it has not been previously admitted. We would ask if the commission is going to put that in the record, that it put the complete document, not the excerpts that were proposed by Montana Farmers Union.
And which IRP specifically?
So I think that 5,
We'd be happy to update this to if what you want to do is have the complete IRP filing that was made last week, I think on May 4th, we're happy to stipulate to that.
and we would ask, we don't think it needs to be admitted in this record. We'd ask the commission to take administrative notice of that docket. It's 2026-0426. That's the current and final IRP submitted to the commission for its consideration.
That's fine.
We would object to MFU 006 on relevance grounds. That's a Northwestern irrigation tariff. We don't think the tariff provisions are at issue in this case, and they don't go to anything of substance before the commission. And would you rather, should we go through these one at a time, or do you want me to go through the list and let you know what we're going to object to?
Go ahead and go through the list.
Okay. We would object to MFU 007 for the same, on the same basis. It's irrelevant. It's an abstract of water rights relative to Northwestern Energy's, one of Northwestern Energy's hydro facilities. Again, it's not relevant. Those rights are not in dispute. It's not relevant to any issues that in dispute in this docket. MFU 008 constitutes hearsay and is not subject to any of the hearsay exceptions that we're aware of, and we would oppose it on those grounds. MFU 009 is the investor transcript, which is already in the record and doesn't need to be readmitted. MFU 11 is, MFU 10 and 11 are federal government productions. But again, they're not relevant to any of the matters at issue in this docket. Northwestern Energy is well aware of the importance of agriculture to Montana. We do not dispute that. We value our agricultural community and our agricultural customers and are not disputing their importance to the state of Montana. And these documents do not add anything to illuminate any of the issues in dispute. In this case, for those reasons and also on foundation and hearsay grounds, we would similarly object to 12 through 16. Those consist of articles and web pages and all of that, which have some interesting data, but again they're not information from this witness, inappropriate testimonial exhibits. And we did make these objections in our pre-hearing memo, Madam Chair. In our pre-hearing objection document, sorry.
Can I say anything here?
No, sorry.
Not yet.
Can I confer with my attorney?
You may.
We can just, I can respond. We'll just keep that. This happens between the lawyers, Madam Chair, if I may.
Yes, you may.
It's the process. I think Mr. Schweitzer has not testified before the commission before. So with a little latitude, we can do this as a matter of law, and then the commission will rule, and then we'll go from there.
Okay, I just want to make sure we have the list correct. So let me confer with my counsel for a moment.
And I can respond when, yes.
Thank you.
Madam Chair, my co-counsel has offered me some assistance, and we're not sure that MFU 003 is in the record. And to the extent that it isn't, we don't object to admission of that.
You don't object to the admission of MFU
Exhibit 3.
03. Okay, so 03 is admitted. We got that one taken care of. It's my understanding that MFU 2 was data requests, and we've already ruled on those data requests and what's admitted and what hasn't been admitted. So to the extent MFU 2 relates to the admitted data request, those are already admitted. And the ones that were not admitted are not admitted. So I think we gave that determination on day one. Regarding MFU 4,
Madam Chair, yeah, those are the LOIs, and we're objecting to those on relevance grounds.
yeah, on MFU 4, the commission finds that exhibit MFU 4 is irrelevant to this proceeding. MFU has not shown a connection between Northwestern's attempts to serve specific data centers and the merger. The commission sustains JA's objections. Okay. And then on MFU 5, I did not hear an objection on MFU 5.
Yeah. They just want the complete document.
Okay.
And,
Take administrative
Oh, that's for the IRP. Okay.
So we can take it.
And may I, on
Yes,
that
go ahead.
specific, on the specific IRP, we accept the administrative notice, but under Rule 1006, Montana Rule of Evidence 1006, summaries are acceptable. And so we would ask that the excerpts that we have identified and have been discussed and are marked in the tabs that we had included as part of the evidentiary hearing and have discussed be included in the record.
Okay.
So, and I'm happy to revisit that in the morning so this doesn't get protracted here, Madam Chair, to give the specific portions of the IRP that we do want included in the record.
Okay, and I believe the joint applicants stated that they were fine with the commission taking administrative notice of that document, but the full document, and I thought you had agreed to that.
I do, but there are some specific summaries within that I would like to have in the record, and under Rule 1006 would like to have the ability to present those.
Madam Chair, Rule 1006 applies to a summary offered by the party propounding the testimony, not summaries existing within a document. We consider the IRP to be an entire document, and bits and pieces of that are not appropriate to have in the evidentiary record. If the commission's going to take administrative notice, it should be of the entire document.
Can I speak? Council, you can highlight pages of the IRP in examining witnesses, but the objection is well taken, and administrative notice would be of the entire document in the other docket, 2026-04-026.
All right, so the commission does take administrative notice of IRP 2026-0426. Regarding MFU 07, the commission finds that this exhibit is tenuously relevant to this proceeding and overrules the joint applicant's objection to MFU 07, so it is admitted. MFU 008, the commission finds that MFU 008 is hearsay unless MFU can show it is admissible under an exception to the hearsay rule. So at this time, the commission sustains the joint applicant's objection to MFU 008.
Madam Chair, we skipped over 006, and I just noted that we did not, I'll withdraw my objection to 006. That's our tariff. We did not lodge a pre-hearing objection, and I'll stand on commission's procedures for that. We'll withdraw on 006 and no objection to the admission of that.
MFU 06 was on irrigation.
It's our irrigation tariff.
Okay, okay. All right, MFU 006 is admitted without objection. And we are now at 10.
Madam Chair, 009 it's the merger conference call from August 19th. It's been already admitted.
That's right. MFU 9 is already admitted.
The remainder of these, Madam Chair, if I may.
Yes, you may.
10, 11, 12, 13, 14, 15, and 16 are public records and reports under Rule 803-8, and they are further, they are records that there are market reports, commercial publications under 803-17, and they're not being introduced for the truth of the matter. They're being introduced to show, to rebut the claims of no harm that the applicants have to meet, and to put some evidence in front of the commission showing that this 8-state region, 20% of the land mass of the United States, will in fact experience some harm as some of the prime agriculture land in the country. So we would ask that those be admitted under those exceptions as Rule 803 if it finds that they are hearsay under Rule 801.
Madam Chair, if they're not being admitted for the truth of the matter asserted, there's absolutely no reason to have them here. The existence of these documents is not in dispute. What they're being submitted is to bolster Mr. Schweitzer's testimony, and what I've just told you is that we'll take Mr. Schweitzer's testimony on face value about the importance of Montana's agricultural community to the nation. What we're not going to accept are these arguments that this merger is going to harm that economy, as there's no evidence suggested in Mr. Schweitzer's testimony or any of these articles to that point.
All right, so MFU 10, this exhibit is actually a link to the USDA's National Agricultural Statistics Services website. It is not a link to a specific report or data supporting Mr. Schweitzer's assertion that the right to states within the footprint of the merged company collectively generate 25 to 26% of the total U.S. agricultural cash receipts. The commission finds that MFU 10 is not an exhibit. The commission sustains the joint applicant's objection. MFU 10 is not admitted. Did the joint applicants object to MFU 11?
We do, yes. On the basis of hearsay and relevance and foundation. It's not a document that this witness has generated. It appears to be, my print is real small. My recollection is this is a blog article, if I remember correctly, from
Exhibit 11 is USDA forecast. This is government data that's publicly available, commercial market reports under 803-17 and 803-8. This is admissible.
Madam Chair, the Exhibit 11 that was produced with Mr. Schweitzer's testimony is from the minority blog of the Agricultural Nutrition and Forestry Committee. It is not a USDA report. It's a screenshot or a production from the minority blog of the United States Congress.
That's right. I apologize. I spoke in error. I apologize. That's right. Mike is right.
All right, MFU 11 is not admitted. This joint applicant's objection is sustained. MFU 12 The commission finds that MFU 12 lacks foundation and constitutes hearsay. The commission sustains the joint applicant's objection. MFU 12 is not admitted. On MFU 15, this exhibit is an article published on the Northern Ag Network website citing an article published by Beef Magazine. The commission finds that MFU 15 is hearsay within hearsay. The commission sustains joint applicant's objection on MFU 15. On MFU 16, the exhibit is a link to the website of Farm Flavor, a private organization. The commission finds that MFU 16 is hearsay. The commission sustains the joint applicant's objection on MFU 16. And I will take a moment to confer with my counsel on the last few here that are not in my grid. I believe joint applicants also objected to 13 and 14, and I don't have a reference to those here in front of me.
And those are on the same grounds, hearsay, lack of foundation, and irrelevance.
And what are those?
13 is an article. It's a blog article from mtpulsecrops.org.
And 14?
And 14 is, that is this is a terrible picture. I think this is also, Madam Chair, I printed a terrible copy of this. Does anybody have that?
By an organization.
Yeah, I think it's.
Ms. Trinnell, can you describe 14 for us?
Yes, I'm sorry. I was getting ready for my next move here. It's Montana organic crop data that is included in the record for purposes of showing the value specifically of Montana's agricultural land.
And that's a link to the organic
Yes.
website. Okay. Okay, 13 and 14 are also, objections to those are also sustained, because these are also hearsay. So 13 and 14 are not admitted. And I think that gets us through the list of MFU exhibits.
Thank you, Madam Chair. And just for purposes of our complete record under Rule 103, we would like to make the offer of proof that the excluded exhibits would show the information and the evidence set out in Mr. Schweitzer's testimony and ask that it be included as excluded evidence for purposes of judicial review.
Okay, so noted.
Thank you. And I think with that, did we get Exhibit 17 in the record?
Madam Chair, Exhibit 17 is his pre-filed cross-intervenor testimony, and that does not have any corresponding exhibits under that, and we do not have an objection to that testimony.
Okay, so Exhibit 17 is admitted.
Thank you. And with that, I would tender the witness for cross-examination.
Would any party like to examine the witness?
Madam Chair, we have no cross-examination for this witness, but we would reserve the right to recross after commission questions.
Okay. Are there any commission questions for this witness? Commissioner Nochi.
Thank you, Madam Chairman. One of the reasons I voted the way I did is so you could testify. Okay? Because most of my district is farming. And what they're telling me is if we don't have water, we don't need electricity. So water is pretty darn important. Okay? Maybe the legislature should tackle this, saying we bring a pipeline in from Seattle and we ain't touching Montana water, which I would support. Okay? Now, the question I have for you is, I'm confused because They tell me that data centers have nothing to do with this. Yet we've discussed again and again how data centers are part of this, right? And it may be separate of the mergers, right? But we got to move carefully here because I don't have enough water and I have irrigation right now. And I can't even get the irrigation that I need when I have vested irrigation rights, all right? If I have less, I'm done.
Commissioner, I think we need to go to questions of the witness regarding his testimony.
Well, I'm going to tell you. We give latitude now and then. And when it comes to ag, we better be given some latitude here because that's our number one industry. Now, I want you to tell me what kind of situation are we going to be in if we don't have enough water? And I understand that we're not tackling the question whether data centers are part of this or not, because I'm confused because I hear it back and forth every day. All right. So tell me, what do we need to do to ensure, what do you want us to do here?
Madam Chair, I'm going to object. This case is not about water. This case is about the merger of two utility holding companies, and we have submitted ample testimony in the case that this will not have any impact or change Northwestern's use of its water rights. And beyond Northwestern's utility asset water rights, the Montana's situation related to water has no place in this docket.
The objection is sustained to the extent that the commission does not have jurisdiction over water rights.
Okay, Madam Chair, I'd like a follow-up question.
Go ahead.
What do you have to, what can you say if we can't talk about water?
Well, I'm concerned about this for a lot of reasons. The control of our water is one of them. The loss of assets that Montana ratepayers have paid for now twice, and we're about to sell them again, and it concerns me, and it kind of is a little bit of a deja vu for me. Because I watched 30 years ago where we had executives from our utility company tell us this is a good idea for Montana. And we had the Chamber of Commerce tell us it was a good idea for Montana. We had the leaders from the legislature, our governor, tell us that this was a good idea for Montana. And so we moved ahead and caused electrical deregulation. And after that, we lost our dams, our generation, our transmission. And it was only 7-10 years later, it dawned on us that it was a bad idea. And so then we tried to reverse it. We tried to get the horses back in the barn, but we didn't get them all back in the barn. And so I'm looking at this idea and it's just scaring the hell out of me. It's scaring the hell out of our members because electricity is important to us. It's our operations. It's how we make a living. Our water is important to us. It's how we make a living. And to flippantly say that this has nothing to do with our water and our access to electricity is disingenuous. Because it's all about that. It's all about the Public Service Commission's ability to protect me. You can do that now when you are overseeing Northwest Energy, when 90% of that is here in Montana. But if we move forward with this acquisition and we lose to where we only have 30% of what you guys have oversight on, and we're at the mercy of a huge company that can move the shells around a little bit with the peas underneath it to keep you guys, because I trust what you've been doing. You're doing a great job. You're protecting our interests, and I love that. And I hope that you will continue to protect our interests. But I just don't know how you can when much of what's going to happen in this new company they're calling is mostly in several other states.
Madam Chair, I am going to jump in. This has seemed to veered into what is now would be considered expert testimony. None of these issues are within Mr. Schweitzer's personal knowledge. He's not been qualified or offered as an expert, and certainly has gone far afield, appointing about this commission's jurisdiction and all of that. As I've indicated previously, we are vitally interested in and committed to agriculture in Montana, as I know this commission is. But allowing witnesses to just soliloquy as we go through this hearing is not an appropriate contested case evidentiary record.
Ms. Trinnell. Oh, excuse me, Commissioner Pinochi. We did stop another witness short of expounding into a narrative. And so I do want to remind us to keep our questions narrowly focused to the expert testimony that's been presented. And if you can find a way to do that, if you have the Mr. Schweitzer's testimony before you and you want to speak to the testimony and ask questions about that, it's completely appropriate. But I think the open-ended questions are probably leading us far afield again.
Well, so much of it has been thrown out here. I'm not even sure where I can go. Okay, how about this? What could you put in front of these guys to say, if you can promise me this, that you'll feel comfortable so that we can move past this? Is that in your testimony? Let me rephrase that. I'll try to do a better job.
It was a good question, Commissioner.
In your testimony, could you frame an agreement between Farmers Union and this merger that you could go back and say, we're protected? Because that is what my constituents are trying to get me to do to represent my district. And I think what you've said that has happened in our past is good testimony for us to be concerned moving forward. And keep in mind, we did have testimony here that now, after this merger, there'll be more out-of-state leadership than in-state leadership.
Madam Chair, now the commissioner is misstating the record.
Okay.
I agree. And Commissioner,
I don't.
You're finished, or do you have a
No.
question? Okay.
Now, look, we established that leadership after the merger will have a greater percentage outside of Montana than inside of Montana. Am I incorrect on that, or did I misunderstand that?
I think the record will speak for itself, Madam Chair. And if that is Commissioner Pinocchi's, I think he's entitled to ask questions of the witness based on what he understands the record to be at this point in time. And that's the purpose of offering additional evidence for the commissioners to inquire into.
I agree. The commissioner may ask questions of the witness. The commissioner may not state opinions or try to restate facts that aren't in evidence, or maybe possibly misstate facts. So if you want to ask the witness if that's a fact, that's fine.
Okay, try it that way. Did you hear testimony that after this merger, there'll be more leadership on this new energy company outside of Montana than inside of Montana?
I did.
Okay, hallelujah. I'm glad we agree on that. All right. So that's my question. That we have that concern. So what can you get in front of these guys that you can agree on? That's all my questions. Thank you.
Well, there are some things that we could bring, but my problem is whether or not they can be truly followed through and enforced. Because to your point, they can agree to what's in the room today, but their board is made up and can re-elect and reappoint and rehire as they see fit. And so then I am concerned that they down the road wouldn't follow through with the protections. And I don't believe you guys will have the power as the Public Service Commission to enforce those protections when you only are dealing with about a third of this monster.
Back to my question, any idea what you'd like to see him do to ensure that you'd be comfortable with an agreement? What would that agreement be in your opinion? And do you have any testimony on that?
Well, certainly, the Montana ratepayers, the Montana members, should have primary access to our electricity. Absolute. And that we should not have any whatsoever burden of the cost of providing the infrastructure and electricity for any large load. That's an absolute and bare minimum. And I don't know that I can get, even if I got that guarantee or promise today from this group, whether or not they could follow through with that down the road, and whether or not you would have the ability to enforce it down the road.
Thank you. No more questions from me.
Okay, thank you, Commissioner. Any other commissioner questions? Commissioner Molnar.
Thank you, Madam Chair. Mr. Schweitzer. Always enjoyed your brother, and you remind me as an honest man as well. Do you think it's possible to have a binding agreement with an organization not yet formed, as a matter of fact, not yet named, that you can take to court and say, here's what we were promised, here's the contract, and have it upheld?
Madam Chair, I have to jump in. This is calling for legal conclusion. This isn't even inappropriate expert testimony.
It's
just asking for legal advice and legal
objection sustained. It is a legal question, Mr. Commissioner Molnar. Do you have another question?
Correct me if I'm wrong, sir. Are you the head of the Montana grain growers, stock growers? I see your name bantied about. What are you head of?
I'm the president of Montana Farmers Union.
Thank you. Mr. Schweitzer is president of the Montana Farmers Union, not as a lawyer, as the president of that organization. Do you feel that you can enter into an agreement that protects your members with an organization not yet named and not yet formed?
I do not.
Further questions from commissioners? Okay, I guess it's my turn. Oh, well, Commissioner Vukacek.
Thank you, Madam Chair. What is your understanding of ring fencing protections for Montanans?
Well, and I believe that it's protecting the assets that are here in Montana, the transmission grid, the electrons that are within the state of Montana. And it's not even all of state of Montana, because Basin Electric has a portion of Montana's grid as well. So it's really, this situation would be just Northwestern Energy's share of it.
Okay. Any other questions? I have a few. Thank you for being here, Mr. Schweitzer.
But thank you for the time you're taking on this.
Sure. Yeah, it's definitely an important matter. And I think going to the answers you gave to Commissioner Pinocci about, what would make you feel okay about this? What do you want? And I think you answered two things, at least that I wrote down, and I want to make sure I understand that correctly. You said that agriculture should have primary access to our electricity because your business absolutely depends on that. Is that correct?
Yep.
Okay. And then you said also that I believe Montana Farmers Union members shouldn't have to bear cost for any new large load that's put on the system. And I assume you're talking about data centers that would come.
Yes.
Any new large load.
Yeah.
Okay. And if those two criteria were met, that would solve your concerns.
Oh, not at all. No. I mean, I am still very concerned losing the control of our utility company once again. It was a very bad experience the last time we lost the control of it, and I don't want to have to live through that again.
Mm-hmm. Neither do I. Okay. I'll just leave it at that and see if there's any redirect or excuse me, recross based on commission questions.
Madam Chair, may I have a moment to confer with my co-counsel?
Yes, you may.
Madam Chair, we have no recross for this witness.
Okay. Counselor, would you like to redirect then based on the allowable commission questions? The ones that
No,
weren't-
I will, I'm not going to ask any redirect. And thank you, Mr. Schweitzer, for your first time experience with the commission. And Montana Farmers Union has ended its case with this witness.
Okay. And so I assume you're asking him to be permanently excused?
Thank you, Madam Chair, that I am making that request.
Okay. Without
No objection, Madam.
Okay, without objection, Mr. Schweitzer, you are permanently excused and
Thank you very much.
thank you. All right, it is 5:09 PM. So I think what we'll do is go to recess for the day. Before we do that, are there any questions from counselors? Here. No? Okay, so I think where we decided we would be then is in the morning, we have Montana Consumer Council witness Ralph Smith. And we also said that we would have Kimberly Nooney back so that Counselor Trinnell could ask questions about the NOLs, correct? Is that tomorrow morning?
Yes.
Okay, and she would be appearing remote tomorrow morning. So I think we have those two in the morning.
Madam Chair, if I might, I understood that Ms. Trinnell reserved the right to speak with Ms. Nooney again, depending on how it went with Ms. Lael about NOLs, but Ms. Trinnell has decided not to question Ms. Lael about NOLs. So I think it's not appropriate for Ms. Nooney to be called back at this time.
Ms. Trinnell?
The conversation I think we had was that the NOLs is it's an issue that's out there. I didn't want to keep Ms. Lael around today if we weren't going to ask questions. It is an issue that I think is hanging out there, and I wanted to be able to follow up to close the loop on that if there's anything out there. And I apologize if I have been unclear in any way. That is not my intent. There's been a lot for me to handle, just to be totally candid. And I think that the late filed data responses to M350 Montana 100 that came in on May 11th actually didn't have a witness identified in that response. And so it was Lael or Nooney. Really, truly, I just want the witness who's most capable of answering a very narrow line of questions on the impact of the NOLs on the corporate structure. And so if one or the other of them will answer the questions, I'm happy to call whoever it is.
Thank you.
So Madam Chair, if I just want to clear up and make sure we're all on the same page. The joint applicants have no objection if Ms. Trinnell wants to question a witness about the emails that were provided, or the one email but multiple from both sides, that was filed on March 11th. May 11th, concerning the NOL disclosures and the risks in our 10K. What I understood Ms. Trinnell just to say is that she wants to ask any questions about NOLs, and Ms. Trinnell had that opportunity when Ms. Lael and Ms. Nooney were on the stand. But if she needed more time to review those emails, we were fine with that, and she can question the witnesses about that email. But anything beyond that email should not be appropriate at this time.
And I agree, that document was produced very late. And so providing Counselor Trinnell another crack at it is fair. And so to the extent that the questioning goes to what's in that document that was filed, the response that was filed May 11th, that's fine. And so Ms. Trinnell, did you want to call one of those witnesses in the morning to address that?
Yes, and I can defer, or if I think they both answered the data request, but I don't see a witness listed in the M 350 Montana 100. So I guess I would request that Ms. Nooney be made available for I don't anticipate 10 minutes of questions, to be honest. I want to ask what the impact of the NOLs is on the corporate structure. That's what I want to get to. And the information that was filed on May 11th updates that and gives some information from January. And I will go through that tonight in all honesty, and try to have a better question in the morning.
And my notes do, for this witness, for Ms. Nooney, do indicate that I excused her temporarily with the condition that she would be available remotely Friday morning, and I believe for that purpose.
Madam Chair, that's fine. No witness's name is on 350-100 because this email wasn't between any witness.
Okay.
The emails were not between any of the witnesses that have testified. I think Ms. Lael is probably in the best position to talk about the emails. And so if there are questions about that email exchange, we would ask that it be directed to Ms. Lael.
Okay. Is that fair, Ms. Trinnell? Does that satisfy you?
I'm running out of steam for procedural wrangling. I really just want to understand, and I think the commission should just have the information. What is the impact of the NOLs? Can Kim Nooney answer that and get the evidence in the record? I think we can be efficient about this. I don't
Okay,
think we
let-
need to argue about who wrote what email.
I don't think that's what we're arguing, but I do understand that it is late, and we are probably, several of us are running out of steam. So,
Madam Chair, if I may,
yes.
all that I'd like to clarify is that we think that substantively the better and proper witness would be Ms. Lael.
Right.
Ms. Nooney was not listed on that on those documents and does not have personal knowledge of them. So we're trying to indicate who the better witness will be.
Right. And I think that's what Council Trinnell indicated that she wanted. So let's plan on Crystal Lael in the morning for limited cross on the response that was submitted May 11th.
And just
Madam
to
Chair.
clarify, those are Black Hills emails.
They are Black Hills email?
They're Black Hills
Northwestern responded.
January information that's on the attachments.
No, Madam Chair, the email exchanges between a individual, an employee of Northwestern in finance, and an employee of Black Hills.
When I opened the attachments, I thought they were Black Hills documents. So if
Yeah.
I'm wrong, I'm
Madam
wrong,
Chair.
but and maybe they
Okay.
were both.
Okay, well, let's just make the witness available in the morning.
Madam Chair.
Mr.
Yeah,
Commissioner.
some of my questions are reserved for Crystal Lael, and then she was off. Is she going to be back on tomorrow to the, you were talking very narrow focus. Will I be able to ask her my questions, or is that not anticipated at this time?
Is there any objections to that?
No objection.
Okay, so that
Thank
would be
you.
fine. Work on your questions tonight and make them narrow.
Hopefully this is posted on YouTube, and so I can try and remember them. Thank you.
We need to get through those. So it will be Miss Lael in the morning, Not Miss Nooney? Oh, she'll be available as well if we need her. Lael will be available. Miss Nooney will be available. Just Lael. All right, just Crystal Lael will be available in the morning regarding the May 11th response. And then we also have Ralph Smith. So we'll plan on that. We'll plan on resuming at 8:30 in the morning with starting off with the public comment portion, and then we'll move into the evidentiary hearing following that. So any other questions from counselors? Seeing none. Thank you for a good day. The time is 5:17 p.m. and we are at recess for the day and off the record.